Thanks for staying with us. Just yesterday, Friday, at about 10 a.m. thereabout, the Supreme Court declared the Naira redesign policy of the federal government invalid and extended the deadline for the restriction put on the 500, 200, and 1,000 Naira notes to be legal tender, also to December the 31st. Now, lawyers have been reacting to this. Economists have been reacting to this. This has become a major topic, especially if the federal government will comply with this particular order. Let's bring in a lawyer. He is Malachy Ugwumadu. Good to have you join us. We do not have Malachy Ugwumadu yet. He's supposed to be joining us virtually via Zoom. We're going to take another break, and then just to try and reconnect with him. We had him earlier. We'll try and reconnect with him. And then, okay, but let's just understand that we have the address made by the state governors. I think it was Governor El-Rufai and Yahaya Bello, who were at the Supreme Court yesterday. Let's just get that up sound from them.
Emefiele was appointed central bank governor by the PDP originally. So let's not forget where he came from. And he's the one that put this policy together to help the PDP win the 2023 general elections and deceive the president into thinking that it is possible to withdraw 2 trillion naira from circulation and reprint everything in 3 months. No country in the world history has done it. The Supreme Court justices today have shown that this is a policy against the people of Nigeria and is invalid. So let's not go back to what has happened last week. The election is over. Our candidate has won in spite of the obstacles. But for us, what is important is that ordinary Nigerians, traders, farmers, and businessmen can now move on with their lives. Go to your bank and collect all your money today. You have the right to do so by the order of the Supreme Court of Nigeria. I know President Muhammad Buhari very well. Part of the reason why I convinced my colleagues to go to the Supreme Court is because we are among the closest governors to the president. And we wanted to show him, if those closest to you disagree with you so publicly on a matter of policy, you need to reflect on it. Okay? President Muhammad Buhari is a man that obeys the law. He may have been misguided by his advisors, but now that the Supreme Court has spoken unequivocally, I am confident that all the
Governor El-Rufai of Kaduna State speaking there. Let's take a break. When we return, we'll be speaking with lawyer Malachy Ugwumadu. Stay with us. Thanks for staying with us. We have Mr. Malachy Ugwumadu now to speak on the order of the Supreme Court. Mr. Malachy, good to have you join us.
Thank you. Thank you for the opportunity. Good afternoon, viewers.
All right, so I want to go straight into it, because one of the things that in its order yesterday, one of the things that the Supreme Court said was that this particular policy was invalid on the grounds that it was not done with due consultation and in line with the constitutional provisions. That's one. It also said that the non-joinder of the CBN doesn't rob it of jurisdiction. I want you to speak on this.
Well, let's take it one after the other. The very important point made by the Supreme Court relating to the need for adequate notice and consultation was at the heart of that decision. The Supreme Court must have taken every fact, every circumstance, and every surrounding issues into consideration in coming to the conclusion that whereas the federal government may have been well-intentioned, the operationalization of that policy ran Nigerians into very difficult and chaotic situation. In other words, the policy came out very badly, as though it was not thought out through properly. So at the end of the day, the Supreme Court took effective cognizance of Section 20 of Section 3 of the Central Bank Act and identified that if the governor of the central bank, at the instance of the president, had mobilized the Nigerian people, educated them, sensitized them, and conducted a pilot operation of this policy, we probably would not have found ourselves in circumstances where Nigerians were dying on the queue, were spending hours on the queue, were sleeping at POS point just to be able to access their money. So that is on the one hand. And I am sure that the Supreme Court, as it ought to, took into consideration Section 20, Subsection 3 of the CBN Act 2007. Now, the other point as to what was your second question?
The fact that the Supreme Court said that, look, the non-joinder of the CBN does not rob it of its jurisdiction.
Very well, very well. That's a very, I mean, you know, it was a kind of shield that the opposing party tried to throw up and confronted the Supreme Court with the point that the CBN was not made a party to the suit. Now, that fell on its face because, as it were, the federal government itself was sued. In short, the Supreme Court assumed original jurisdiction as a court of first instance because it was a dispute between the states and the federal government. That is one of the very few exceptions where you can just pick your bag and run to the Supreme Court for adjudication of a matter. And therefore, being the federal government, the central bank is merely an agency of the federal government. And the Attorney General, being the chief law officer of the federal government, pursuant to Section 150 of the Constitution, was also a part to the litigation. So the Supreme Court came to its finding that the absence of the Central Bank of Nigeria as a party, stricto sensu, did not divest it of its jurisdiction and overrule them. So that cleared the way for the substantive application that was determined yesterday, as it has turned out. And it is, to a large extent, it is kudos to
Mr. Malachy, are you still there?
Yes, I am.
All right.
Perhaps that was a network glitch.
Absolutely. But let me take you to... All right. I will just give you like a minute to wrap up that point, and I'll ask you the next question. Please go ahead.
Very well. So the conclusion of my position on that point is that what has happened, first of all, establishes the point that Nigeria, however difficult and against all odds, is practicing constitutional democracy, where the legislature, in short, the arms of government operate as a check onto each other, even if they are independent and autonomous. However, the judiciary has stood tall in this instance in establishing itself as a court, the Supreme Court of Justice of Nigeria, as well as a court of policy. Policy in the sense that where the policy of the executive, as represents this particular instance, where it works hardship, where it inflicts pain, where it undermines the liberty of Nigerians, and orchestrates even harder livelihood for the citizens of this country. The Supreme Court has a responsibility to look closely at the law and find a way of reversing that, and that is what has happened. So, but
Mr. Ugwumadu, do you expect? I just wanted to ask you, because you said something about making life better for Nigerians, but in that particular ruling yesterday, the Supreme Court said the president's broadcast demonstrates his disobedience of this court, that's the Supreme Court, and that the president ought not to be heard in this court. And perhaps it's the first time we're seeing the Supreme Court use a very strong tone against the presidency in terms of his compliance to any of his ruling. Do you expect the presidency to comply to this particular order?
The presidency or the president has no option. He has no choice. In short, I am referencing section 287, subsection 1 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. It creates no avenue for choice. It is a peremptory, compulsory, mandatory provision of our grown law that insists in very clear terms that every person, every institution, every agency, every authority, including the presidency, is obligated to obey and enforce. One yesterday was the ruling of the Supreme Court of Nigeria. And that order, that ruling must be enforced. So as regards the question of obedience, that is not up for any choice. Now, when the Supreme Court referenced the brokers of the president, that was a technical point that the Supreme Court made in order to reinforce its position.
Where we leave it, we'll continue to speak to lawyers and follow developments on this particular issue.